Yes, Your Honor.
Okay. 1 second. Okay, we're on the record in Pajolo versus Kroll. This is file number 2512012. The record should reflect Mr. Kroll is present today by video from the Crawford County Jail. Miss Pajolo is not present. This is set for a hearing today. Mr. Kroll, you filed a motion to terminate the personal protection order in this case. Is that correct?
Motion to modify or terminate, Your Honor.
Okay, what are you asking the court to do?
I would like to terminate it because she was apparently forced to file it in the first place to get her child back.
Okay,
And she would be willing to fully drop that, Your Honor.
Okay, well, she's not here to say that.
She's got a lot of court appointments, me too. So me and her just talked yesterday, and she was totally unaware of this court date being today. She thought it was next week or tomorrow or something.
All right. Well, I also have information that you were arrested for home invasion, violating your bond, and violating this PPO. Is that true?
Yes, sir.
Okay, so she's not here to tell me she wants this drop. You're telling me that's what she wants, but you've also been arrested for home
well,
charge.
Right now is probably not a good time to modify it or terminate it. Maybe modify, but I'm still in jail, so it doesn't make a difference. So we're gonna probably just need to reschedule, to be fair.
Yeah.
Or I don't know, maybe get her to come in and talk to you.
Yeah, I would completely agree with you on that. So what I'm gonna do is I'm not gonna make a ruling today. I'm gonna adjourn this without a date. I will give you an opportunity to refile this motion. So call the court, ask for a separate date. I'll give you another date, and then we'll see where we go from there.
Okay, yes, sir. I question, how long do I have to do that? Because I know we're past the 14 days. I just got myself 15 days in here. So how long do I have to file that?
So you filed your original motion within the time frame. I'm extending that time frame based on the circumstances.
Correct.
And so I'll give you 30 days to refile that.
All right, thank you, sir.
Okay. All right, that's all for today then. The court's going to disconnect this time.
Today's hearing took an unexpected turn the moment. William Kroll popped up on the Zoom screen from the Crawford County Jail. The judge started with the basics, confirming his name, confirming the case, and pointing out that the protected party, Ms. Pulo, wasn't present for the hearing. And that's important, because Kroll was there asking the court to terminate the personal protection order against him. Right away, things got rocky. Kroll claimed that the only reason Ms. Pulo filed the PPO in the first place was because she was forced to in order to get her child back, and that she now supposedly wants it dropped. But the problem, she wasn't there to confirm any of this. And while he was trying to explain, the judge cut straight to the biggest issue. Kroll had just been arrested for home invasion, violating his bond, and violating the protection order he was trying to get rid of. That alone set the tone for the rest of the hearing. The judge essentially told him, look, this is absolutely not the time to modify or end this order. You're in jail. The protected party isn't here, and you've already violated the order multiple times. Even Kroll admitted that rescheduling the hearing might be the only fair option at this point. From there, the judge made it simple. He wasn't ruling on anything today. He adjourned the hearing with no new date, told Kroll he could refile the motion, and even extended the deadline for him due to the circumstances. Kroll got 30 more days, but no progress on what he came for. And honestly, the biggest moment of this whole hearing wasn't the judge's decision. It was the way Kroll unintentionally undermined his own case. The moment he openly admitted to violations, his entire argument collapsed. It showed exactly why judges rely on verified facts, not emotional explanations or claims from someone who already broke the order. In the end, this hearing was a perfect reminder. The courtroom runs on proof, presence, and accountability, assumptions and excuses. And sometimes, the most damaging testimony a defendant gives is the one they volunteer all on their own.